right. Well, good afternoon, everybody, and welcome to the Maryland Insurance Administration's Property and Casualty Industry Meeting. My name is Kathleen Bohrain. I serve as the Maryland Insurance Commissioner, and I look forward to an informative discussion today. The purpose of our industry meeting is to discuss 2022 legislation, regulations, operational issues, and any other matters of concern to the industry. We thank everyone who sent in questions and agenda recommendations in advance. Before we get to our agenda, I would like to take this opportunity to introduce my colleagues from the Maryland Insurance Administration who will be speaking today. First, Robert Barron, who's the Associate Commissioner for Property and Casualty.
Morning. Good afternoon, everybody. Pleasure to be here.
Mary Quay, our Associate Commissioner for Market Regulation and Professional Licensing.
Hello.
Joy Hatchette, the Associate Commissioner for Consumer Education and Advocacy.
Welcome, everyone.
Joe Smith, the Acting Associate Commissioner for Insurance Fraud and Producer Enforcement.
Good afternoon, everyone.
Lisa Larson, Director of Hearings and Regulations.
Hi, everyone.
And Craig I, who was our Director of Communications.
Hello and welcome.
This public industry meeting is being recorded today and will be posted on the Maryland Insurance Administration's website. We have a very robust agenda, but as time and technology allow, we do want to hear from you. So please let us know using the chat feature that you would like to speak if you have any questions or comments that you would like to make. To help ensure excellent sound and video quality throughout the meeting, we ask that you please stay on mute with your video off unless you're speaking. And now I will turn it over to Robert Barron, who is going to run our agenda today.
Good afternoon, everybody, and thank you, Kathleen. Thank you all for joining us today. We are always happy to arrive at this point of the year, post-legislative session. We can share the results and outcomes of the session with industry stakeholders, and we also take this time to provide an update on the state of the Property and Casualty Division here at the MIA. I want to start this afternoon by just taking a moment to recognize and thank the Property and Casualty Division's management team and our frontlines staff and support staff for their daily efforts in support of our customer service and regulatory responsibility missions. It's because of these dedicated public servants that we enjoy a positive working relationship with our licensees and the people that we serve. At the MIA, we are honored that we so frequently receive positive recognition from our various constituencies for the work that we do. And I'd like to just highlight an example, a recent example for you, and recognize Denilsa Marciniak, who is our Director of Consumer Complaints, for her recent receipt of a governor's citation for excellence in customer service that was presented to her by the Lieutenant Governor and the Comptroller at a Board of Public Works meeting earlier this month. It is, again, dedicated civil servants like Denilsa and the rest of the P&C division staff, and in fact, the MIA staff overall, that enables us to do the work that we do and enjoy the positive reputation and relationships that we enjoy. So with that, I want to give you all a bit of an overview of what's happening in the P&C division and start with the some information around our consumer complaints team. The consumer complaints team continues to operate with great efficiency within a mostly remote work environment. We've been highly successful at enrolling our P&C licensees into our digital platform, our ECTS portal, which enables us to efficiently and securely communicate with our licensees in our complaint investigations. And it's important for our licensees to notify us anytime there is a change in their designated contact person for consumer complaints. It is imperative that we are always up to date with where our communications on complaint investigations are to be sent. So in your organizations, if you've got transition due to whatever reason, retirement, people moving on, promotions, whatever it might be, just please keep us informed when anybody in that particular role changes. We'd also like you to know that the P&C division is working presently in partnership with our hearings unit to implement some new efficiencies in the handling of complaints that are made under Section 271001 of the insurance article. That's our lack of good faith claims handling statute. Our licensees also have designees for designated individuals for communication in the 271001 complaints arena. And again, it's important that we are kept abreast of who those people are, what their contact information is, and to the extent that there might be any changes, please let us know promptly. Complaint volume is, after a few years of it having receded a little bit, it has sort of leveled off, and we are quite current in the complaints teams. So if you find that there happens to be something on your radar that you think might have fallen off of ours, please reach out to Denoso or myself so that we can look into it and make sure nothing has fallen through the cracks. The same is true on our rates and forms side. So we'll segue into some conversation about the rates and forms team. Our rates and forms unit, again, is working, continuing to work efficiently in a mostly remote environment. We do want to take some time out today to remind our licensees and the filers for our licensees about some important filing protocols. It's super important when our licensees are getting ready to hit, that send button in SURF to drop a filing on us, that you make every effort possible to follow our filing instructions, complete all the relevant fields that we require. The better job that you all do up front before you hit send in SURF to hit us with a new filing, the more efficient we can be in receiving, processing, handling the filing, and turning it around quickly for you all. I want to talk briefly about rate impact filings and remind folks that we have designated fields in SURF under the rate rule schedule tab that must be filled out by our filers. The effective date and the percentage of the previous rate revision has to be indicated in the appropriate fields in SURF. Without that, we don't know, without doing extra work and time-consuming work, whether a particular insurer has made a recent filing for rate in the same program. Really important for us to understand and know that rate history. So please make sure that you're looking, doing a final check of the rate rule schedule tab in SURF, and that the previous rate revision filing information is there. You also have to be cognizant and remember to complete the company-specific line for the current rate filing that indicates both the indicated rate percentages and actual rate percentage impact that's being taken. There's a field for the number of policyholders and the written premium that we need to see. Very important to complete the fields that indicate the minimum and maximum impact for that particular filing. These are standard fields that this is nothing new, that we've always looked to our filers to complete for us. We've noticed recently just a little slippage there. And so we just want to bump it back up onto your team's respective radar screens so that you can make sure that you are helping us out. And by doing that, we can be as efficient as possible and turn your filings around as quickly as possible. Those minimum and maximum rate impact fields are also viewed in tandem with the histograms that we require each of our filers to provide on a rate impact filing. We look closely at that material, and we expect that our filers can explain any outliers, particularly on the increased side of the rate impact. So we always hope to see a minimum maximum range that's fairly narrow. We understand that there can be outliers, but we want to make sure when we see that what that represents, and make sure that we're okay with that. And so you should expect when you have that in a filing, that we'll ask about it if we don't see the explanation within. So please be cognizant of that. I want to continue in the discussion of filings and talk briefly about the private passenger auto and commercial auto lines of business. We recognize, you'd have to be living in a cave to not recognize that there are economic realities in play in the market today that certainly have some impact on insurance premiums or insurance rates. We have seen an uptick in automobile rate impact filings, not one that we can't stay on top of, but we have seen that uptick, and we are closely examining all rate impact filings in these two lines of business. We ask that in light of the inflationary environment that exists, that our licensees in all lines of business, but in particular those that that affect the personal line side, automobile and home, for example, to consider the use of rate stabilization factors. If you have not put that into your rate calculation mechanism, that's something to consider. We want to assist consumers in avoiding, and certainly you all would have this same best interest at play. We want to, try to reduce what we call the whipsaw effect of rate changes. Rate stabilization factors can help with that. Many of our licensees have that in play already, and we ask if you don't, that you might want to consider looking at those. It is difficult for consumers to understand and cope with large increases. And we want you to know that, you know, it's not sufficient to simply point at inflation as the sole basis for a rate increase filing. Seen a couple of filings that, you know, cite to things like the consumer price index and kind of, you know, leave it there. That alone is not indicative of the actual impact on your rate needs. And so it needs to be provided in tandem with your actuarial support for you know, current frequency and severity data. We expect to see the most current frequency and severity data that's available across all coverages. We are telling our filers, and we want you all to know, it's no trade secrets here. We are looking at, you know, 5 to 10 year result windows for combined ratios and policyholder surplus levels. And our expectation is that insurers will use all of the tools that are at their disposal to be both fiscally responsible in, you know, establishing their rate requirements, but also highly aware of the effect of rate changes on consumers. And so as you know, we move forward, and hopefully, you know, we'll see some reversal of the inflationary trends that we've been seeing. But as we move forward, we want you to know that you should be including in your actuarial support exhibits that speak to your history of results in the combined ratio metric, and also policyholder surplus levels. With that, segue to our 2022 legislative session. I think we have 5 bills that we want to that were enacted that we want to cover briefly this afternoon. And the first of those is Senate Bill 278, House Bill 377, which authorizes MAIF, Maryland Auto Insurance Fund, to file installment plans with us on a prior approval basis with some new guidelines in place than what existed previously. So little fewer restrictions, some lighter restrictions on the nature and type of installment plans that MAIF can file. We are anticipating that bill has an effective date of October 1, 2022, and we do anticipate MAIF will make a filing with us this summer with the anticipation of offering new installment plan options to their applicants on or after October 1. So we wanted to just point that out. And the next bill is Senate Bill 425, House Bill 568. And for that piece, I'm going to turn it over to our Associate Commissioner for Market Reg and Professional Licensing, Mary Quay. Mary?
Thank you, Robert. So Senate Bill 425 modifies sections 17.322 and 17.604 of the Business Occupations and Professions article. And those apply to real estate brokers, associate real estate brokers, and real estate salespersons. The first edit removes the prohibition on payment of compensation for provision of real estate brokerage services as to a title producer acting in accordance with the new subsection C of the section. And that states, during a property settlement, a licensed title insurance producer may, on behalf of a real estate broker and in accordance with a written disbursement authorization provided by the real estate broker, pay compensation to an associate real estate broker, a real estate salesperson, or a business entity formed under section 17.512 of that title. The MIA notes that section 10.130 of the insurance article prohibits any compensation for selling, soliciting, or negotiating insurance to anyone other than a licensed producer. So long as the payment is made in accordance with the wording of the changes to the statute and is a payment by the title insurance producer on behalf of a real estate broker and is not for selling, soliciting, or negotiating insurance, then we do not see a conflict between the statutes. The MIA enforces the insurance article and will investigate allegations that an insurance producer has violated the insurance article. But we do not enforce the laws that regulate real estate brokers. And we will probably be following up on this with a bulletin in the future.
Thanks, Mary. Next couple of bills I will provide an update on. Senate Bill 572, House Bill 563 concerns the policy fees that are authorized to be charged by qualified surplus lines brokers for policies issued in the non-admitted market. The bill updates section 27-216 of the insurance article to allow a qualified surplus lines broker to charge a reasonable policy fee for personal lines policies. The fee cap has been raised from $100 to $200. That's the first increase in that fee cap in probably 20 years. And then for commercial lines that are not in the exempt commercial market, the cap has been changed to be a reasonable fee not exceeding $500 or 7% of the policy premium, whichever is greater. The bill did clarify our existing position that there's no fee cap for non-admitted policies issued by a qualified surplus lines broker in the commercially exempt space, as long as the insured or the risk has signed off that they meet the statutory requirements for commercially exempt status. There is no cap. However, in all of these instances, the fee that is charged must be a reasonable fee that is related to the actual cost of underwriting, issuing, processing, and or servicing the policy by the qualified surplus lines broker for the surplus lines insurer. We are putting into place some monitoring mechanisms so that we can track the impact of this particular bill on the policy fees that are charged in the non-admitted market. You can look for a bulletin soon, I would say definitely in early July, that will describe for you a small change on the surplus lines quarterly report form that all qualified surplus lines brokers must complete after the close of each calendar quarter. The change is simply an addition of a single new column on the form where the qualified surplus lines broker will be able to list the actual policy fee for each policy written. In the past, the form has included the fee within the the gross policy premium, and there will still, that column still exists on the form, so you'll still show that in that fashion, but you'll also be required to segregate out the fee. We're going to, the bulletin will be, will provide more specific directions, but our objective is to actually put this in place during the summer so that when the third quarter ends, the qualified surplus lines brokers will be able to complete the new form, that new column on the existing form, beginning with the results for the third quarter of this year. And that form would be required to be filed by November 15th because it's 45 days after the end of the quarter. We don't think there's much of an issue there. We've been told already by the participants in that market space that they have that data readily available and will be able to implement pretty seamlessly. So be looking for that bulletin in the next few weeks. And then briefly, Senate Bill 697, House Bill 926 concerned vehicle repair contracts. And the bill amended section 15-311.2 of the transportation article and provides an obligor in the vehicle repair contracts space with additional options for meeting their insurance obligations by obtaining a policy or policies of insurance from a risk retention group, in addition to either an admitted or non-admitted insurer. And with that, I'd like to turn it over to Commissioner Borain, who's going to talk to you about Senate Bill 207 and cybersecurity standards.
Great, thank you, Robert. So just briefly, so let me start by saying I want to thank the members of the industry for what I thought was ultimately a very constructive exercise and getting to, I think, what was a really good place for Maryland in passing this legislation, which I think is a really important and frankly critical item of consumer protection in the state. So thanks to those who were constructive in this process and helping us get to the right place. Senate Bill 207 adds Title 33 to the insurance article to establish cybersecurity standards and reporting requirements for the licensees specified in the definition of carrier. Section 33-103 of the law requires a comprehensive written information security program to protect non-public information and a written incident response plan for cybersecurity events. The law includes specific requirements for the security program and for the incident response plan. The law takes effect on October 1st, 2022. Carriers have until October 1st, 2023 to implement 33-103 and an additional year to require compliance by vendors pursuant to 33-103H. Implementation is delayed an additional year for carriers that have fewer than 25 employees. So, and are below thresholds set in the uncodified text of the bill for gross annual revenue, total assets, or annual direct written premium. On or before April 15th of each year, each carrier is required to submit a written statement certifying that the carrier is in compliance with the requirements of 33-103. Details of the information required to be in the notice are specified in the statute. Carriers that are not domiciled in Maryland are exempt from the filing requirement if the carrier is domiciled in another state or U.S. jurisdiction that has adopted a law or regulation that is substantially similar and files the required certification with its domestic regulator, or if the non-domestic is within an insurance holding company system that has implemented an information security system that has been approved and is maintained by another carrier within that same insurance holding company system that meets the requirements for an exemption. Following a cybersecurity event, The carrier will have to notify the commissioner as promptly as possible, but no more than 3 business days, excuse me, after the determination that an event has occurred. A cybersecurity event must be reported if Maryland is the carrier's state of domicile and the event has a reasonable likelihood of harming a consumer residing in the state or harming any material part of the carrier's normal operation. For a carrier that is not domiciled in the state, a cybersecurity event must be reported if the carrier reasonably believes that the non-public information involved is of 250 or more consumers residing in Maryland, and either notice is required to a government body, self-regulatory agency, or other supervisory body under state or federal law, or there is a reasonable likelihood of material harm to a consumer residing in the state or to a material part of the carrier's normal operations. The information required by the notice is specified in the statute. The MIA will be issuing a bulletin with other information regarding reporting and other elements of the bill. We expect that bulletin will be out by the end of the summer. And because of the nature of it, it's my intent in this instance to pre-publish the bulletin for comment before we finalize it. And with that, I am happy to turn it over to Associate Commissioner Joy Hatchette and Acting Associate Commissioner Joe Smith to discuss public adjusters.
Good afternoon again. The purpose of bulletin number 2207, which was issued yesterday, is to remind public adjusters of those provisions of Subtitle 4, Title 10 of the insurance article that regulate compensation agreements between public adjusters and the insureds who they represent, including the disclosure of compensation received by a public adjuster from contractors or other vendors performing services for which a consumer is seeking coverage under an insurance policy, and the handling of settlement funds received on behalf of insureds. The administration is aware of contracts entered into by public adjusters with an insured that purport to waive the public adjuster fee otherwise due under the contract if the insured uses one or more specifically identified contractors or other vendors recommended by the public adjuster. The administration is also aware that in some instances where the purported waiver applies, the public adjuster actually receives compensation from the contractor or vendor whose selection by the insured triggered the fee waiver. It is the position of the administration that in such instances, the fee is not actually waived, but rather paid by the contractor. While receipt of compensation by a public adjuster from a contractor, salvage firm, or other vendor is not prohibited, it must be disclosed in writing to the insured, and it must be included in the itemized statement of compensation received by a public adjuster in connection with a loss that is mandated by the insurance article. Failure to fully inform the insured that the public adjuster is being compensated by a recommended contractor or other third party, and to characterize the fee as waived may violate the insurance article. Such arrangements with a contractor could, even with disclosure, constitute a conflict of interest or a violation of the duties to serve the client with complete loyalty enumerated in section 10.414 of the insurance article. The administration is also aware of arrangements between construction companies and public adjusters in which the construction company steers the insured to a particular public adjuster who agrees to represent the insured without compensation by the insured and accept a fee from the contractor. Such arrangements may violate sections 10.409 of the insurance article by offering an inducement to the insured to engage a public adjuster. Further, absent full disclosure of the payment to the public adjuster, such arrangements may violate the insurance article. The administration has also identified instances where a public adjuster has forwarded the insurance settlement funds directly to the contractor as opposed to depositing the funds in a non-interest bearing escrow or trust account in a federally insured financial institution. Evidence of this conduct may violate the insurance article. The exact public adjuster statutes are enumerated in the bulletin. And
Thanks, Chief. I think Associate Commissioner Hatchette, are you next?
And just briefly, Joe really focused on the issues related to public adjusters, but we also have been seeing somewhat of an uptick in issues relating to contractors and things of that nature. And we would just like to remind you, as you work in the industry, if you come across any fraud or suspected fraud by either public adjusters or contractors, please refer those items to Joe's unit so that the appropriate investigation can take place. It's in all of our interests to make sure that we protect the Marylander consumers and make sure that your policyholders are not taken advantage of.
Thank you, Joy. With that, turn it back over to Commissioner Moraine, who will provide an update on some recent administrative cases in PNC.
Sure, thank you, Robert. I wanted to take just a moment to talk about two administrative opinions that were issued recently that dealt with the concept of standing and in actions that are or consumer complaints that are initiated at the Insurance Administration and who has standing to seek a hearing on a determination by the PNC unit. This is an issue that comes up a lot. There are many motions for summary decision that are filed that challenge who is aggrieved and not aggrieved. And we have, over the course of the last couple of months, had a couple of opinions that have come out to address these issues. There are more working their way through the process. So I thought it made sense just to emphasize and two of them. And they speak for themselves. So obviously you'll read them and you will interpret them. But the first one I wanted to point out was the MIA XREL Featherfall Restoration LLC versus the Travelers Home and Marine Insurance Company. And that's case number MIA 2020-10-014. Obviously, the opinion is on our website. And I would note that this case is on a petition for judicial review has been filed with respect to this case. This one deals with a first party claim where the policy owner was a homeowner who had a restoration service stop by and to look at roof damage. And so the restoration service and the homeowner believed that there was damage to the roof from a hailstorm that had occurred a year before, and the restoration service facilitated the making of a claim with the insurance company. The insurance company came out, they did their inspection, they did their investigation, and in relatively short order, they denied the claim, saying it really was wear and tear. It was not it was not as a result of the hailstorm. There was when that occurred, there was what purported to be an assignment. So this is a circumstance relating to when the claim, that first party claim against the insurer, has been assigned to a contractor. Is that assignment valid? Will the MIA recognize that assignment as something that then gives that contractor standing to bring an administrative complaint with our PNC unit? And the short answer to that question for this case was no, that in that particular homeowner's policy, there was language that prohibited the assignment of any rights under that policy without the consent of the carrier. And so what this opinion does is addresses the circumstances in which such assignments are valid or not valid and the circumstances in which a non-assignability clause will be recognized. So I suggest that people take a look at that because, again, it addresses who has standing to seek a hearing. Now, I will tell you that the MIA has a much more measured approach, or perhaps a more laid back approach with regard to who can bring an issue to our attention. So we certainly have a very open door where there are complaints about carrier conduct or alleged misconduct in terms of initiating an investigation and reviewing conduct. Because there are times when, regardless of who brings something to our attention, if we believe that there are violations of the statutes that are occurring, we're not dependent upon the existence or non-existence of a consumer complaint in order to address those things. So it is typical for the MIA to, regardless of who might technically have standing or might technically be harmed, to evaluate behavior. But when we've made the determination that there is no violation, then the question becomes who gets to take that on to the next level. And that's based on the statutory requirement that only someone who's aggrieved can do that. And so this opinion digs down into who is aggrieved and what does non-assignability language mean, and under what circumstances could an assignment provide standing to a stranger to the contract under an assignment clause. So anyway, that's the first one. The second one, this case is Maryland Insurance Administration. Oops, that's the same one. Maryland Insurance Administration XREL OS versus State Farm Insurance Company. Now, this also involved a circumstance where there was an assignment. In this case, it was an assignment of the right to pursue action against an insurer with respect to a diminished value claim. So this was a case in which there was an automobile accident. This was a third-party claim. So State Farm's insured hit OS in OS's vehicle, and State Farm acknowledged the claim and it paid the claim as it was originally submitted. But then a year or so after the original claim was submitted and paid, there was a follow-up claim that was made on behalf of a company that's in the business of helping to evaluate diminished value, whether or not there's been a diminished value, and helping those claims to be made. So that entity then submitted a supplemental claim, if you will, to State Farm seeking that diminished value, and State Farm denied it. And eventually the matter was brought to the Insurance Administration. Now, this was a very different legally analytical circumstance because here we were now talking about a third-party coverage. So it wasn't the first-party claim where the policyholder has a contract claim against the carrier if the policyholder disagreed with the carrier's denial. Here we have a third-party claimant. So an individual who is not in privity, who does not have any rights under that policy until they have a judgment. So they have no basis to go against that policy until there's a judgment against the insured. So the analysis there is very different. And an assignment can have no real meaning in that context in any event, even though there was a non-assignment clause in that policy as well, because there are no rights against the carrier to assign prior to a judgment. And so in that instance, what we really focused on was more around the administrative rights. So the legislature has provided an opportunity for a claimant to complain about the claims settlement activities of the tortfeasor's insurer. And that's a very limited, very narrow right that exists by statute, provides a very limited set of behaviors that can be the subject of a complaint. And if violations are found of the Unfair Claims Settlement Act, then the administration, having found those, can issue a penalty, which can include restitution. So with that sort of framework, our assessment was that those administrative rights and those administrative remedies are personal to the injured person. and they are not assignable. And so the analysis of the case law is in the opinion, but I wanted to make sure that people were aware of them and that they understood sort of the distinction between first party and third party. And these are sort of, as we work our way through a series of cases, we will be refining those issues around standing. So that is the gist of I think what we wanted to underscore for the industry with respect to those issues.
Thank you, Commissioner. Going to turn it over briefly to Lisa Larson, our Director of Hearings and Regulations. And so we'll give you an update on regulation activity here in PNC. Not a whole lot right at this moment, but I think Lisa's got just some words about our process for you to hear. Thank you.
Thank you, Robert. Good afternoon, everyone. Yes, so as Robert said, we don't have a lot of regulations affecting the PNC industry that are currently in the process, but we just wanted to give everybody a very brief kind of overview, reminder of our process here. What we typically do with our regulations is we post what we call draft proposed regulations on our website prior to moving through the official proposal process. Those regulations are typically put on our website and include a comment period of typically 30 days, sometimes a little bit less, but they're always listed on our website. As a reminder, if you're not subscribed, we ask that you subscribe to that page. You can find the regulations on the MIA website under the Regulatory Activity tab. And then this specifically would be under the Draft Regulatory Activity portion. And then right on that page itself, there's a button that says subscribe to this page. If you click on that page, you can enter your email address and get added to our listserv so that you would be notified when any regulations are posted on our website so that you can be kept abreast of them when they're posted and, you know, review them and make any comments you see necessary. So with that, I'll turn it back over to Robert.
Thanks, Lisa. I did just see in the chat, Nancy Egan asking about the case number for the State Farm case. To make it easy on everybody, I'll just send out to everybody that was invited today either a PDF or a link. We'll figure that out. We'll send it out to everybody for both the Featherfall matter and the State Farm OS matter. We'll send that out.
And then in the meantime, I happen to have it up on my screen.
Oh.
So it's MIA 2020-08-018.
Thank you, Commissioner. We're at that point. We do have about 8 minutes left in our hour. Craig, did we have any pre-registered speakers today?
We do not.
Okay.
We do have one question in the chat, however.
Okay, and I saw that that question went back to the cyber bill. And the question is, what about carriers in states that don't have a similar regulation but are licensed in other states that require similar, for example, New York?
So Tami, could you clarify, are you talking about certification, the annual certification? Is that what your question's directed to?
So I was really just looking for some guidance on, I mean, if we end up with 50 states wanting us to do 50 different certificates, it's going to become a burden. And right now we do this robust filing for our mortgage and insurance companies with the state of New York for cybersecurity, including our disaster response plan and, you know, so forth. And so we were just trying to determine, you know, are we going to be having 50 filings? Is most of the states that have put in cybersecurity rules have exempted non-domestics. So we're just trying to get a handle on, you know, how much work is this going to be going forward? Is Maryland an outlier asking foreign insurers to do this? Or, you know, are we going to be just burdened with creating, you know, ultimately 30 to 50 certifications based on each state's own regulation? And you know, also being aware that the NAIC is has been working on, regulations to that regard as well.
So as the chair of the H committee, I can tell you that I think, intimately aware with what the NAIC is doing. And I can't really tell you what every other state ultimately is going to do. But what I can tell you is that after much discussion and much compromise, where we settled in Maryland was that we would require an annual certification with exemptions. And so I think that if there are specific questions, about the exemption and what you fall into, we're happy to entertain those questions.
But if you're a foreign insurer and you comply with the New York reg, then it doesn't qualify you for the exemption, as opposed to if you were a New York domestic, you would qualify for the exemption because New York not only requires it for their domestics, but they have extraterritorial rights and require it for their foreign insurers as well.
So I think that it's probably more nuanced than that. But the statute is what it is. And if you want to take it offline in terms of a particular circumstance that you're referring to a particular client of yours to see where that fits into the, the grouping, then we're happy to have that discussion. But the statute says what it says.
Yeah, thank you.
Nancy Egan has raised her hand.
Nancy?
Hi, Robert. This is just a quick update for you and everyone else on the phone. Phil Dacey had reached out to us on Monday about possible legislation by the Motor Vehicle Administration dealing with the cancellation codes used for FR13s. And he was trying to get feedback from us, and I suggested that he have a meeting with the subject matter experts at each insurance company, that he should consider having us all talk about these FR19 cancellation codes. Their concern was that carriers are using the all other code when they don't know what to put, which was like 400,000 of the codes for cancellation. So they're trying to come out with some either regulatory or legislative answer to that, because it ends up they need to get like manual documentation for like salvage title, et cetera. So they're holding a meeting on Friday, I think at 10 a.m., Robert, and I will send that information over to you. I've sent it out to the people that participate in our insurance industry call. And we've also shared it with the board of the IIA MBA, that group that tracks that across the country. So I can send it to you, Robert, and whoever you think might want to monitor it. I just wanted to give you an update.
Okay, thank you. Appreciate you sending it my way. I think with that, we are getting close on the end of our hour. Commissioner Brain, any closing remarks?
No, not really. Just to remind people that we are going to flow through a separate link, but we're going to flow into the hurricane readiness meeting.
Actually, it's on the same channel, Commissioner.
Oh, okay. Well,
Yep.
well, then we're literally will flow into it.
All right, so thank you all for your attendance and participation today. To the extent that we ran out of time and you might have had additional questions, please feel free to email me, and we will be happy to further respond. And we have a few minutes. Those of you who are not interested in the hurricane session can log off, and we'll be starting again shortly with our hurricane preparedness call. Thank you.